Okay, everyone, given that we're running a little bit behind, we'll start now and we'll move to the trade practices aspect of it, and Adrian Muller will present practical tips for dealing with the ACCC. Thank you.
Thank you, Greg. In a film called The Princess Bride, a short, rotund Sicilian has two propositions that he puts to his adversary. He says, never mess with the Sicilian where death is involved, and never start a land war in Asia. Now, I'll put that second one to you as a proposition. When you're dealing with the corporate regulator or with the ACCC, do you really want to start a land war with them? I'll come back to that, but hold that thought in your heads as we talk about the dealing with the Australian Competition and Consumer Commission. I've given you a paper. It sets out, by and large, the regime in relation to compulsory examinations and a few other points. I don't propose to talk to that. What I propose to do is to give you 3 short points and bring 3 other things to your attention. But just as an aside, and perhaps as an assistance to some of you, there's now a new act. So if you go looking for the Trade Practices Act, you won't find it anymore because it's now the Australian Competition and Consumer Act 2010. Just to make things a little bit more difficult, that Act introduces the new Australian consumer law, which is where we find all the old provisions, such as Section 52, misleading or deceptive conduct, or the provisions in relation to consumer protection. But that's not in the Act itself. That's found in a Schedule 2 to the Act, and that's done for various constitutional reasons. But when you're looking for things now, you need to look for the Competition and Consumer Act 2010, and if you want those consumer provisions, you need to look to Schedule 2 of that Act. In dealing with the regulators, and by and large I'm talking about the ACCC, but it applies I think also to any of the other regulators. The first thing I think that we need to do as lawyers is to consider our client's position. And as Simon alluded to, often that needs to be done on very short notice because the first you'll know about it is where a client turns up waving some sort of notice and says, I have to appear in an examination tomorrow, or I've been told to produce documents tomorrow. I think our obligation as lawyers is to, at that point, work out what it is that the ACCC is investigating, what the scope of their investigation is, and what our client's role in that investigation is. So are they a protagonist, are they a participant, are they an innocent bystander who might happen to have some knowledge about events that interest the ACCC? And you can look often at the terms of the notice, which will set out, as Simon said, in relation to ASIC, and it's the same in relation to ACCC, some of the provisions that the regulator is looking at investigating that give them the power to conduct the investigation. And then going through the process of taking instructions from our client, and I think importantly at that point starting to give them some advice on the likely scenarios. And that includes working out what's the client's best case, what's their best outcome, what's the client's worst case outcome, because that starts to govern the approach that the client, or the recommendation of the approach that we make to the client about how they then deal with the regulator, and on their behalf how we deal with the regulator. Because it varies significantly if your client is the target of the investigation or the protagonist, or whether they're just a participant or someone who can assist with the investigation. If they're simply a participant, then, or someone who's got knowledge or factual understanding that might assist the regulator, then being open and frank and making full disclosure with the regulator might be the best and cheapest thing for your client to do. It might also be the best and cheapest thing for your client to do if they're the protagonist, but we'll come back to that. And the other thing is to work out what's important to your client. What do they want out of what do they want as an outcome? What do they see as the most important things to them? It might be that they quite understandably want to avoid any criminal sanctions. It might be that they want to avoid any sort of civil penalty, and they're prepared to give enforceable undertakings or make corrective advertisements. It might not be that. It might be that they insist that they want to put the ACCC to its proof and make them prove a case against them. It might be that they want to be completely exonerated because they say that they're not either on the facts or at law guilty of the offences that the ACCC are investigating. So you need to, I think, take all of those instructions and start to put together a package of what it is that your client's exposed to and what it is that your client wants as a best possible outcome and what other considerations are important to them. So I think that's the first point that we need to do, and often I appreciate it needs to be done very quickly because of clients sitting back on notices and taking some time to come in to see us, but it's a crucial step in the process. The second thing that I think we need to do is we need to consider the regulator. So we need to step into our adversary's shoes at that point and ask ourselves some questions like, how serious is it likely to be viewed by the regulator? So the conduct that the regulator is investigating, where does it fit in their scale of concern? And dealing with the ACCC, there are areas that are perennially hot for the ACCC. They are always concerned about misuse of market power. They are always concerned about cartel activity. So if you've got a client who's possibly involved in those sort of breaches of the Consumer and the Competition and Consumer Act, then you know that that's going to be something that rates highly on the ACCC's radar. But then there might also be areas that are, for various reasons, what you might say politically hot at a period of time. So is the ACCC under external pressure from government or other agencies to take action or investigate in particular areas? Because that will start to inform you about what sort of resources the ACCC is prepared to put into the matter, whether they will be looking for a short and easy out, which might lead you towards something like an administrative resolution or enforceable undertakings, or is it something that they are looking to use as an example to other people, and so, or as a way of bedding down new areas of law. So in 2009, for example, the ACCC got the power to investigate cartels at a criminal level. So they could not just seek civil penalties, but start to seek criminal sanctions as well. That's obviously an area that interests them. It's an area that is new and developing, and it's an area that they are likely to pursue with vigour. That's very different to if you've got a client who's got a bog standard misleading or deceptive advertisement that the ACCC is taking exception to for some reason. That's much more likely to be able to be dealt with by a corrective advertisement or something like that. Thinking about what the regulator is likely to view, or how the regulator is likely to view the scenario that you find yourself in, is important. A second element of that is, how's the regulator likely to view your client? Are they looking at him or her as an innocent bystander or a participant with information or the protagonist? And then once you've started to think about that, you might think it a bit further and say, well, how else are they likely to view my client? Are they looking at him or her as honest but stupid? Are they looking at him or her as honest but reckless? Or are they looking at him or her as dishonest and stupid, or dishonest and reckless? All of that will inform what you might say is the level of heat that the regulator has towards your client. And that's an important consideration, because I think at the end of the day, what you need to be mindful of, what we need to be mindful of as lawyers, is that we're dealing with people on the other side. So ultimately it is people who will make decisions about how hard to prosecute, how many resources to put into an investigation, and it's natural and human for them to do that based on their perceptions of the target. Now, it doesn't mean that if you've got a client who has committed various breaches of the Act and has been involved, if you like, in setting up a cartel, that just because they're a nice person who acted recklessly, they're going to get off. I'm not suggesting that at all, but I am suggesting that at that initial point, as you start to look at how the regulator might be viewing your client, it gives you an opportunity to shape that story and shape how the regulator sees your client over the coming weeks and months. So consider what your client's position is, consider what the regulator's position is, as best you can understand it, and then the third and critical thing is develop a strategy. And that becomes, I think, the most important thing that we can do as lawyers outside making sure that our clients' legal rights are protected is, what's the outcome that we want to manoeuvre this investigation towards? What's our, if you like, what's our case theory about where our client sits and how they should be seen? Do we want an outcome where the client is exonerated? Do we want an outcome where the client has sought immunity from the ACCC in return for cooperation and providing further information? Do we want to negotiate some other sort of outcome? Do we want to negotiate a form of advertising that's acceptable to our client and to the ACCC? Do we want to offer up undertakings? Or do we want a contested outcome? Do we want to look at what legal defences there are available and say, well, even if the conduct as the ACCC is viewing it occurred, that at law that doesn't amount to a breach of the Act or a breach of the provisions? Or do we want to say, well, it might be that our client has committed breaches of the Act, but we know that the ACCC is going to have a lot of difficulty proving it. So what we want to do is put them to proof. Depending on what the outcome your client is looking for will govern how the client goes about the conduct of participating in the investigation. For example, if the client wants immunity, I should say under the Act, then there are provisions where, and the ACCC have policies about it, and I've referred to them in the paper. A person who comes forward and is first in time in relation to cartel activity and offers full and frank cooperation and ongoing cooperation and assistance to the ACCC can, in certain circumstances, get immunity from prosecution. And that's obviously is a very attractive proposition for some people. If that's what the client wants as an outcome, then the lawyers need to move very quickly to be first in time, and they need to start to line all their ducks up so that their client can continue to provide full and frank disclosure and ongoing assistance. It's a very different situation if what the client wants is to put the ACCC to proof about the matters that it thinks has occurred. Because in that situation, it's likely that all the client will do is to provide what they have to provide under statutory compulsion, attend examinations and answer questions with the most brevity possible in the circumstances, and let the ACCC conduct an investigation without any assistance from them. Two very different scenarios, and unless you have worked out at the start what you want the outcome to be from your client's perspective, then you're not going to be able to nuance and manage the detail of the investigation and your responses to it. And that comes back very much to the starting point that I had, which was don't start a land war in Asia. And I think usually the proof of a rule is in the exceptions, and Dick Pratt is a good exception to the rule. He started a land war in Asia with the ACCC, and by and large, eventually he won it. But that was a person with enormous personal resources and the ability to engage in a long, drawn-out battle with the ACCC and pay the costs associated with that. You might have a client that can do that. More likely than not, you won't. And so one of the things that is important to factor in is what's it going to cost your client if they wage war with the ACCC, and can they afford to pay that cost? Because it's not going to be in your client's interest to start a war that then they find 6 or 12 or 18 months in, they can no longer afford your fees and barristers' fees and investigative accountants' fees and the like. So that becomes another factor to consider in your overall strategy. Can I just they're the 3 points that I wanted to make to you. So consider your client's position, consider the regulator's position, and develop a strategy and do that early, that dictates your response to the investigation. I just want to draw 3 other things to your attention. And they are that in relation to cartel practice, the ACCC has a published immunity policy. It's if you subscribe to the Miller's service or you get the hard copy, it's reproduced in there, but it's also on the ASIC website. It sets out in quite some detail how ASIC will view an approach from a client for immunity, the circumstances in which they'll do it, and the way that they will implement that policy. If you find yourself with a client who may have participated in some sort of cartel behaviour, then obviously that is a very important consideration for the client. Do they put their hand up, and do they assist the ACCC in return for immunity? There are a number of stringent conditions in relation to that. It's a complex area because you can't put your hand up on behalf of both a corporation and an individual, so as lawyers, working out who we act for at that point is important. Are we acting for an individual who's going to the ACCC seeking immunity, or are we going to acting for a corporation who's going to the ACCC seeking immunity? I just draw that to your attention. I also draw to your attention, and I've referred to it in passing in the paper, is that the ACCC now has powers under Part 11D of the Act to enter premises and search and seize. And they can do that in 2 ways. They can do that by cooperation of the occupier, or they can do that by getting a search warrant and attending the premises. And so I draw that to your attention because unlike the process that ASIC go through with the Federal Police, the ACCC can do it themselves, and they can take along people to assist them. So they can bring along a computer expert, for example, who can make copies of hard drives. They can bring along people who can help them identify particular documents or programs on computers that need to be seized. And they can either take copies of information and materials, or they can actually do things like physically seize the computers. And the final point that I'll draw your attention to is that under the new Act, the ACCC got a new power, and that was the power to conduct a random audit in relation to franchisors. And that's found in section 51 ADD of the Act, and then it applies to the franchise code, which is part of the Act. It's a separate part at the back. There's an obligation on franchisors to provide or to keep and archive all documents and information that they're required to provide to franchisees, and you'll see that that's all set out in the code. And that includes documents like disclosure documents, franchise agreements, receipts, professional advice statements, etc., etc. The ACCC can serve a notice on the franchisor requiring them to produce various documents within a 21-day time frame, which is different to the other provisions for production of documents that doesn't specify a time frame. Usually what it specifies, the Act doesn't specify a time frame, so the Act will say that a notice can be served, and then the ACCC or ASIC will say that has to be done by such and such a date, which, as Simon said, has to be a reasonable time. Under section 51 ADD, the franchisor has 21 days to produce these documents. It's unlikely that the ACCC will consider very favourably a request for an extension, because these are documents that the franchisors are required to keep. So it's now, I think, important, if you're acting for franchisors and you're advising them, to also advise them that they need to keep their records that they're required to keep under the code in a way that are readily accessible and recoverable, so that they can provide them to the ACCC if a notice is issued. There's no legislative time limit on how far back the ACCC can ask for documents. So again, as a matter of prudence, clients should make sure that they have kept documents in a form that they can access for quite some period of time. And that might mean that they need to either update their computer systems or print out documents in hard copy and store them in a physical location so that they have ready access to them. That was all I proposed to talk about, so I'll hand you back over to Greg.
Thanks, Adrian. Now, if anyone's got some quick questions, Adrian or Simon would be happy to answer them. No? Phoebe?
I had a quick one. Section 19 interviews and their transcripts, if a third party subpoenas them, are the answers that were given under a privilege protection redacted or edited out?
Yes, they are redacted. Usually they're redacted for relevance. I'm not sure, I haven't seen them, and they might well be redacted. They won't be redacted for LPP because it's an LPP question. There'll be an objection to answering the question on the grounds of LPP if that arises. Privilege against self-incrimination, you have to answer the question and then claim privilege. I don't think that they'll be redacted for those answers because the reality is everyone claims privilege now. You find my name, privilege, Simon Rubenstein, address, privilege, blah, 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 age, privilege, blah. It just becomes a matter of course and no one's ever going to know whether the answer truly is privileged or not until it's tested. So I haven't seen them redacted for privilege. It's usually relevance, whether they are relevant to the ambit of the request.
So can I ask a quick follow-up?
Sure.
Can then those answers not be used directly but indirectly in other proceedings to put someone on a train of inquiry that they then find evidence to support the answer?
Yes, they can be. The only protection that the privilege claim gives the examinee is that the answers that they've given can't be used against them in subsequent criminal prosecutions or proceedings that might impose a privilege against, a penalty against them.
Thank you.
Simon, a question for you. Where the ACCC has made a finding or obtained an enforceable undertaking and it publishes that, it usually will publish it on its website as well, and there's no time limit as to how long that's available and how long that opprobrium continues to be out there in the public against the client who's had that finding. Is there any technique that you've ever used to cut that short to a reasonable period?
No. Yes and no. No, mainly, in very exceptional circumstances. I can talk about ASIC. I assume that ACCC situation is the same, but ASIC have a media centre on their website, and all of the media releases going back to the first media release ever is available for public viewing. ASIC has an enforceable undertaking database. I would presume the same exists with the ACCC. Every enforceable undertaking ever given or offered up to ASIC is available for public scrutiny on that database. It's part of the conditions of, or the policy in RG 100 that ASIC effectively state is one of the conditions for the giving up or the giving of and accepting of an enforceable undertaking. It's there for all eternity. There's one exception that I'm aware of, and I'm sure that there are others, was a AAT hearing. ASIC are usually pretty quick to rush to put up banning decisions if they've banned an investment advisor or a financial planner or so on and so forth. And I recall one matter where the AAT, an application was made to the AAT to review a decision by an internal decision maker, and an order was obtained from the AAT maintaining confidentiality of the name until that process had been completed. And ASIC had put the media release up and was required once the order was made by the AAT to remove it. That's the only example that I'm aware of, but there's since been some case law in the federal court about the AAT's the circumstances where the AAT will order that a name ought to be suppressed, and it's getting more and more difficult to suppress names. Even in circumstances where there's a good chance that you're going to get your person off, that is, you think that the decision maker the initial decision maker has made a very poor decision and it's going to be overturned on AAT, very, very difficult to get the name suppressed these days.
That's my experience also, that the ASIC will rush to publish the fact that they've charged someone with offences. They don't necessarily publish the fact that they're acquitted of the charges, but the fact that they have been charged. Every media release is coded with a number, and so you can search them by name or number, and the fact that someone's charged will remain there. The fact that they've been acquitted may not even appear. All right. Well, it's getting time to start the working day. I'd like to thank you all for coming along and thank our two speakers for a really great insight in what to do.